Here are the top 10 estate planning objectives that we see here at ELG Estate Planning. Hi, I'm Lynn St. and I'm an estate planning and elder law attorney here in Washington State. The number one objective people have is to make things easier on their family. You have probably heard horror stories about what happens when there is not a good estate plan in place. And so getting your estate plan in place really accomplishes that objective of making things easier on your family. So let me explain how an estate plan makes things easier on your family. Number one, your will. We've all heard of wills and we know what a will does. It passes your assets upon your death to whomever you want to receive your assets. And so if you don't have a will, there is a lot of uncertainty about, well, where should your assets go? The term for not having a will is called intestacy. And every state has something called the laws of intestacy. And the state is trying to figure out what you would have wanted, what most people want, but it may not match up with what your wishes are. So to make things easier on your family, just be clear. Say who you want to inherit from you and what do they get, and meet with an estate planning attorney because they probably have a lot of good strategies to make it easier. Sometimes we actually avoid a probate because it's easier to do that. Sometimes we'll recommend, no, you really should have a probate because there's so many benefits to having that. So you taking the time now to do that sort of planning, to meet with an estate planning attorney, will accomplish that really important objective, that is, make things easier on your family. Protecting your spouse is something that is really important to our clients. That's one of their top concerns. When people come and meet with us, one of the things they say is, I want to make sure it's easier on my spouse, my wife, my husband when I'm gone. And the types of concerns that people have is, they want to make sure that they're taken care of. They want to make sure that there is enough money. They want to make sure that there's not outside influences or state involvement or court involvement. So part of doing a good estate plan is making sure your spouse is protected. At ELG Estate Planning, we are experts on Medicaid and asset protection. Now, why are you concerned about that? You might not be, but one of the biggest threats to anyone, especially if they are a retiree or a senior, is when they pass away, they're worried that their spouse might not have enough money, especially if they need long-term care costs. So one of the things that we're able to do with our wills, which have asset protection trusts in them, is to ensure that the surviving spouse will always have money, no matter what happens in their life, no matter if they need long-term care costs. How that's done is, when the first spouse dies, now Washington's a community property state, so let's just assume half of everything this couple has will go into an asset protection trust for the surviving spouse. So let's say the estate is $500,000. We know that half of that, $250,000, will be in a trust for the surviving spouse. Let's say that the surviving spouse needs long-term care. Let's say that they've run through all their money and now they're saying, how am I going to pay for my care? Well, the state and the Medicaid program will pay for that surviving spouse's care, even though they have $250,000 set aside in a trust solely for their benefit. The normal rules for Medicaid is the person can only have $2,000, but when you do a will with an asset protection trust for your spouse, those rules really don't apply because the money in this trust doesn't count against the surviving spouse in case they ever need long-term care assistance. So that's just one of the ways that we can help guide our clients to make sure that they provide for their spouse. Protecting your kids is a big estate planning objective that we find with our clients. And it makes sense. Most of us are really concerned about making sure that we do right by our families. So protecting kids can run the gamut from, do you have minor children? Do you want to make sure that if you die early and so that you're not there to raise your kids, that you've nominated somebody to be your minor children's guardian, and you want to make sure that you provided sufficient monies so that they can be raised. That money would be in a trust to provide for them their education, those sorts of things. So protecting kids includes the situation when you have a minor. How you do that is through a will and through talking with your estate planning attorney to make sure that there's going to be adequate resources. If you're a younger person, buying term life insurance is a very inexpensive way to making sure that if you die prematurely, that your family is going to have enough money, that there's going to be ample money in a trust to raise your kids. Now, it's not just minor kids that people are concerned about. A lot of families experience issues with, drug, alcohol abuse. This is not that uncommon. And when we're talking with our clients, we talk with them about that. What's the best way to make sure that your child, adult child as it may be, when they receive their inheritance, that it will benefit them, that it won't cause them harm? As you can imagine, receiving an outright inheritance to somebody who has bad choices, lifestyle issues, really could cause them harm as opposed to benefiting them. So one of the ways that you can accomplish that is through your will. We can include in that will an asset protection trust for your adult child. What that does is that puts this protective mechanism around the money. The money is for their benefit, but they are not in charge of it. You're going to name a trustee, somebody that you know is going to be involved in your child's life, and they're going to be there to help them and give the child the money in an appropriate way so that they really will benefit. Maybe they do need help with, purchasing a car or help with purchasing a house or those sorts of things. And if you gave that money outright to that at-risk child, the money would all be blown, and that doesn't do any good. So instead, you can put it into a trust. A trustee will manage the money for that at-risk child that you have, and then they'll get the benefit of what you have worked so hard for during your lifetime. It will benefit that child, and it'll do so in a way that doesn't put them at risk of any harm. Another concern that parents often have for their adult children is, what if my adult child gets a divorce and they've just inherited from me? A lot of people don't want that divorcing in-law to get all the money that would have gone to the adult child. So a way to protect against your in-laws getting the money that you want to go to your adult child is to put it into an asset protection trust. So how that works is your will contain an asset protection trust. On your death, if that child of yours is facing any kind of legal threat, be it divorce or a lawsuit or debt, anything that could put that money at risk, then the executor of your estate, rather than giving it outright to that child, will instead put it into a trust. And because that money is in trust, and because the money came from you, so it's not the child's money legally, nobody can touch that money that's in the trust other than the trustee and other than for the benefit of your child. That means if that adult child is getting a divorce, going through a divorce, or has other creditor problems, those creditors, that divorcing spouse, won't get your money. Family dynamics really come into play when you're doing your estate plan. And really, everybody has their own unique family dynamic. So let's take a couple of examples. Let's say you're a single person and you have 3 children and you are estranged from one of your children. You may want to disinherit that child. How do you do that? How do you make sure that that child isn't going to inherit 1/3 of your estate? Well, first of all, make sure you have a will, because if you don't have a will, your child will inherit 1/3 of your estate. That's called the laws of intestacy, and that's what they provide for. So If that's not what your objective is, what can you do? You know, whenever you have this situation, it's really important that you get counsel from an estate planning lawyer, because it's not the situation that's so easy. It's not something that you could do on your own. Do get guidance from an estate planning lawyer. What they may recommend for you is, let's do a will. And in that will, what you'll say is, I have 3 children. You have to name the child you want to disinherit. If you don't name them, for some reason the law thinks you forgot about them, and they will inherit 1/3, no matter what your will says. So you must name that child you wish to disinherit. And then all you say is, I make no provision for the disinherited child. And the other 2, for example, will inherit equally. That's all you need to do under the laws in the state of Washington. Sometimes people go, well, I want to name them and I want to give them $1 because I heard somewhere that giving them $1 makes it more bulletproof that they don't get to inherit. Wrong. Do not provide anything for that disinherited child. They have no rights under your will if you give them nothing. But if you give them $1, well, then they have more rights than they otherwise would have had. So don't give them $1. So where does that come from, that you might want to give your child $1? There are clauses in a will that are called no contest clauses, Latin ad terrarium clauses. Those are intended to keep people from contesting your will. However, to be effective, if you really want to make sure that somebody doesn't contest your will, you have to provide for them enough money to be a disincentive. So for example, let's say that you want to give the majority of your estate to one of your children. You want them to get 75% of your estate, and you don't want anybody else to contest it. You're going to have to give enough money to somebody else so that they are not incentivized to contest. So maybe 25% of your estate, maybe that's $25,000. That's usually enough money that people will say, okay, I'll take it and I won't contest it and say that I should get half and my brother should get half. So I know that these are kind of confusing, complicated concepts. There's a lot of misinformation out there about no contest clauses and what's the best and most effective way to set up your estate plan. So I really encourage you to see your estate planning and elder law attorney if that's your situation, to make sure you've set up your will so that it really is bomb-proof. An estate plan done right can help you avoid paying taxes. So there are all sorts of taxes if you think about it. There's income tax, there's sales tax, there's property tax, capital gains tax, estate tax, inheritance tax, death tax. So what are we talking about? Well, when people are thinking about avoiding taxes on their death, they're typically thinking about avoiding those types of taxes that are imposed because of the death. So let's say you are a very wealthy person and you have $100 million. You're going to be concerned about estate taxes because the current federal estate tax level is just over $11 million. And that is all that you can pass to a person tax-free. The rest of that other $89 million is not going to go tax-free. You're going to pay taxes on it. Well, you can bet that people who have $100 million have very good lawyers working out very good tax strategies for them, so they're not going to probably pay that kind of estate taxes. So let's bring it down to a more common level. Let's say you've got $1 million and you live in the state of Washington, and you go, I don't want to have to pay any estate tax when that $1 million goes to my child. Good news. You won't pay any estate tax in Washington because, as I mentioned, the federal level is at 11 million. 1 million is less than that. The state tax here, the exclusion amount in Washington, is just over $2 million. So if you have less than $2 million and you live in the state of Washington, you are not going to be paying any estate taxes to the state of Washington either. That's one type of tax. And there's a lot of states that have no estate tax at all. So if you are of a higher net worth level, oftentimes people consider living in those other states. But Washington, we are at about a $2 million estate tax level. What about other kinds of taxes? You may be familiar with capital gains taxes. So let me give you a little bit of an example about what a capital gains tax is. So let's say you bought stocks, and when you bought them, they were worth $10,000. And then when you go to sell them during your lifetime, well, they've appreciated up quite a lot, and now they're worth $110,000. So your gain, your capital gain on that stock is $100,000. And depending upon what your income level is, you're going to pay 15%, maybe even 20% tax on that gain. So that's $15,000 to $20,000. So that's how capital gains taxes work. And one of the good things to know, one of the things that's really important to know, at least under our current tax code, is that when someone inherits from you, when they inherit that stock, it will get an adjustment in tax basis, meaning it'll get stepped up to the current fair market value. So let's say you didn't sell that stock during your lifetime. Instead, that stock that you bought for $10,000, you pass that to your daughter through your will. And when you die, that stock is worth $110,000. And she decides now, well, I'm going to sell this stock now because I would like to get the money that the stock is worth. So it's worth $110,000. You bought it for $10,000, but it's worth $110,000 when you die. She sells it for $110,000. What's her capital gains tax liability? Surprisingly, it is 0. Not 15%, not 20%. It is 0. The reason for that is the stock got a step up or an adjustment in basis as a result of your death. So no capital gains tax is owed on that. So the point of it is that inheriting assets is really advantageous. This doesn't work just for stocks. It works for real property, investment property. So under our current tax code, if you want to make sure that your kids don't have to pay capital gains tax, don't give them the asset now, give it to them through your will upon your death. When would the government become involved in your business? Typically that will happen if during someone's lifetime something happens to them such that they are unable to manage their own affairs. Maybe they've been in a car accident, have a traumatic brain injury, have had a stroke, maybe they have Alzheimer's or some sort of progressive dementia. That's typically the opportunity when the government might become involved in their business. Now, whether or not the government actually does become involved really has to do with what sort of planning did that person do before they became incapacitated. The most important estate planning documents you can have during your lifetime are called durable powers of attorney. Durable powers of attorney keep the government out of your business. If you have a durable power of attorney, you have granted authority to somebody you trust to manage your affairs if something should happen to you. You've granted somebody the ability to manage your financial affairs. You've granted somebody the authority to manage your medical affairs. So with good durable powers of attorney, it is highly unlikely the government will ever become involved in your affairs. If you don't have good durable powers of attorney, or if you have none, if something happens to you, there's nobody with legal authority to manage you and your financial affairs. In that event, the state steps in. There is a court-appointed guardian. So there's a guardianship proceeding. It's in the court. The court takes a look at your situation. They appoint somebody to be your guardian. And that guardian is there to manage your affairs. As an aside, Britney Spears is currently under a guardianship. In California, it's called a conservatorship. But the reason for that is when this court proceeding was started, the court deemed her incapable of managing her own affairs, both financially and personally. And in order to protect her from being at risk of herself or at others, the court felt that there needed to be a conservatorship or a guardianship over her. Now that's a pretty unique situation. That doesn't involve most people. Given the age she was at, etc., it's not something that our clients typically would be involved in. Typically though, if you are not a celebrity and you're not at risk of all sorts of things happening to you, you would simply protect yourself from court intervention by having durable powers of attorney. One of the highest priority objectives for our clients is making sure the right people are in the right place to make decisions for them. Oftentimes people say, I want, my spouse to be my executor. And then maybe they say, well, I don't know who should be next. We'll take the time to talk through, well, who should be next? Sometimes people say, well, I think it should be my oldest child because they're oldest, and then we go to the middle child and then to the youngest. Well, then we'll have a conversation. Well, who has a level head on their shoulders? Who is responsible? Who can basically do the job, get the job done, and do it efficiently? And they might say, oh, well then that's my youngest child. My youngest child is an accountant, for example. Really good business sense, gets the job done, knows what she's doing. Whereas maybe the oldest child is somebody who might be, a great person, but not quite so capable of getting things done in a business-like perspective. Because when you're giving somebody the job of an executor, they need to get the job done. So you want to give it to somebody who is really capable. Another type of decision maker that is part of doing estate planning is somebody who's going to speak to your doctors if you can't. That's called your healthcare agent. So this is somebody who's speaking for you during your lifetime, not after your death, but during your lifetime. Let's say that you're in the hospital and you can't talk to your doctors, and there needs to be decisions made about, well, what kind of medical treatment are you going to receive? Well, you're going to want to appoint somebody, could be your spouse if you don't have a spouse, or even if you do, it might be that child who knows you well, who knows exactly what you want, who you communicate with them with, almost telepathy. I mean, you're that close to them. But beyond that, not only do they know you well, do they know your wishes, but they will be your advocate. They will speak up for you. They will be your voice. So when you're thinking about, well, who is going to be the right decision maker, it really depends on the role that they're going to be assuming. So you might want to have somebody who is your healthcare agent, who will be your advocate, who will speak your voice. And that might be a different person than who would be your, financial power of attorney or the executor of your estate. So we really have to look at, what do those roles encompass? What's going to be expected of that person who is going to be your decision maker? And again, if you have questions about, well, what are these roles? What are they supposed to do? Who should I choose? Or maybe you don't even have family members. You're looking at, well, maybe should it be a friend? Should it be a sibling? Should it be a professional? An estate planning lawyer is going to help you answer those questions. It might be the most important objective that people have when they're doing an estate plan, and that is having peace of mind. If you've been thinking about, what your situation is, are your affairs in order? If maybe you already have an estate plan, but you're not quite sure if it really fits your situation anymore. Does it accomplish your goals? That really weighs heavily on people. We find here at ELG Estate Planning that once we've worked with clients and we have the right estate plan in place for them, they go, phew, a weight is off of my shoulders. I feel it already. Whenever anything is on your mind, at the front of your mind, well, you're probably going to go seek out estate planning services. At the back of your mind, it might be nagging at you. You should get it done, but you can put it off because there's no real urgency to it. What I can share with you, what I can tell you is once people have come in, met with us, done their estate plan, really what they say is, it's the peace of mind. It's knowing that I've done the right thing, I've protected myself, my family, my assets, and I don't have to worry about it anymore. So that peace of mind really is probably the most important thing that people get from doing a good estate plan.